in the matter 27 25 TR 500 500 504 and 26 TR 53 State of Wisconsin versus Brandon Daniels. The 26 matter be entered on his behalf. As to the other matters, for status, here for status, the parties have reached an agreement, and you would just like a sentencing date.
Yes, Judge. Yes, Judge.
I could do February 13th, February 19th at 9 or 11.
Neither of those are going to work. If you could do slightly earlier, 8:30, I could do it. I need to be in Polk County by 10.
I can't.
Okay.
I can't.
Okay.
What about 2:45 on February 10th?
No.
2:45 on February 11th.
Yes, that would be fine. Yes, that would be fine.
2:45 February 11th. We'll see you then. You can come get your notice and come get your notice and your.
Can I get a case number for that 2026 matter? Was that a 26 matter? Was
Yeah,
that a
it's
ticket?
26. Yeah, it's 26 TR53.
Thank you.
It's an operating restricted control substance first.
Mr. Daniels, I'll talk to you about that later.
Okay. All right. Kevin Sanders.
I received a voicemail from Ms. Sanders who was not going to be able to make it in person.
I think, and Jacqueline Anderson.
Both yes.
Assistant gave them the Zoom.
Thank you.
So Sean Schaff. I do not have them on Zoom.
We'll worry about that when the time comes.
We will go on the record in the matter 25 CF 25 TR 291 293 State of Wisconsin versus Sean Schaff. The state appears through Attorney Kevin Schmidt in person. Mr. Schaff appears in person. Daniel Chapman. For status conferences. Mr. Chapman, please update.
Your Honor, the matter is resolved. We are eventually going to be asking for the joint recommendation. Mr. Schaff needs to work out a timeline when he's going to be ready to begin serving a mandatory sentence. Part of that is going to be based on medical surgery scheduling, and he has a test tomorrow, and after that he'll know more information. I'd ask for another status in and hopefully we'll be able to give you a specific date. He'll be ready at that point.
Can you do February 24th at 2?
No, I'm in Hayward that afternoon.
February 27th at 10:30.
I'm in Polk County at 10. And I'm back here at 11. Yes.
Let's just do 11. February 27th at 11.
Get what information you get back to me before then. We'll talk before then, and she'll have a notice for you.
Off the record, but for your record, I understand the pleading, and if you're pleading and minimum, I'm willing to give you some time. Because I understand, I understand all those things. I'm not in a rush because you are pleading.
Following your bond. Thank you.
So I just want to get an idea of your medical stuff. But again, I would be willing to give you a little bit more time. All right, Mr. Ullman. We will go on the record in the matter 25 CM 102 versus Carl. The state appears, Attorney Kevin Schmidt, Mr. Ullman appears in person with counsel Daniel Chapman. We're set today in this matter for plea and sentencing. Mr. Chapman, can you please recite the agreement for the record?
Your Honor, this offer was contingent upon Mr. Ullman getting an alcohol and drug assessment, doing whatever recommendations were required from that assessment. He has done his assessment. He's participating in outpatient treatment 10 hours a week at Fairview
Recovery Services in Edina.
Based on that, the state has agreed to guilty to disorderly conduct with a joint recommendation plus the $100 surcharge.
All right, and Mr. Ullman, that's the agreement that you've reached. Victim rights compliance. Yes, sir. I have in front of me a questionnaire waiver of rights form. Do you recognize the document? Did your attorney thoroughly go over that document with you? Did he essentially go over it word for word?
Yes.
And you understand everything completely? Is that your signature on the second page?
Yes.
61, you have 12 plus years of schooling, you can read, write, you understand the English language. Your attorney went over with you, the state would have to prove your guilt beyond a reasonable doubt, and the maximum penalties, is that all correct? And there are no mental illnesses or disorders, drugs or medication.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the page of the plea questionnaire. Did your attorney thoroughly go over those rights with you? Do you understand them completely? Do you need me to go over those rights with you in any more detail? Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, could result in your deportation?
Yes.
Do you understand? The state would have to prove on or around June 28, 2025, that in Burnett County, Wisconsin, you caused bodily harm to KST by an act done with intent to cause bodily harm to that person's consent, and that it is a domestic relationship. Do you understand what the state would have to prove?
I do understand. What were the initials that you used?
KST.
I believe the initials are KMT.
All right. So KMT. There's a KST and a DMT that I have.
Yes, those were also present.
And so you understand the maximum possible penalty up to a $10,000 fine, 9 months of incarceration, plus a $100 surcharge.
Yes.
And do you understand that I'm not bound to follow the agreement that's been reached, and the agreement here is for costs only. Do you understand that? I could sentence you to the maximum penalty if I thought it was warranted. Do you understand that? You still wish to proceed and enter a guilty plea? Did you go over the criminal complaint with your attorney? That original charging document that has basically this is what happened.
Yes, I did go over that with them.
Showing you a copy of that right now. For the most part, are those facts accurate? For the most part, are those accurate facts?
Yes.
Do you need hearing assistance?
I am hard of hearing, but I can understand here.
Just making sure.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis? Has anyone made any threats or any promises to you for you to plead guilty today? You're doing so freely and intelligently. You fully understand what you're doing.
Yes.
And voluntarily.
Yes.
Oh, actually, I went over the battery with you. Pleading disorderly conduct. And scratch that. Disorderly conduct. The state's going to have to prove in a private place engaged in violent, obscene, or unreasonably loud, or otherwise disorderly conduct. Do you understand what the state would have to prove for that? And do you understand? And the maximum on that would be $1,000 fine up to 90 days of incarceration, plus the $100 surcharge. Do you understand that?
Yes.
Now, you're admitting guilty of disorderly conduct with domestic abuse surcharge and component to it. Is that correct?
Yes.
Mr. Chapman may use the probable cause section of the criminal complaint for the disorderly conduct.
Yes, Your
Has
Honor.
anyone made any promises to you for you to plead guilty to the
No.
charge? You're doing so
No.
freely and intelligently telling the court you fully understand what you're
Yes.
doing and
Yes.
voluntarily. Has your attorney
Yes.
represented you competently?
Yes.
Has he answered
Yes.
all of your questions?
He has.
Are you
He has.
satisfied with the services? Any questions for the court or your attorney before we
No, ma'am.
proceed? Then
No,
asked
ma'am.
to count disorderly conduct with the domestic abuse attached. How do you wish to
Guilty.
plead? Court will
Guilty.
find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of counts 1 and 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered. Mr. Schmidt, argument.
I think the plea to this for cost is appropriate because of the steps he's taking in dealing with his issues, as evident to me by defense counsel, and just what happened with the case. This is a case where Mr. Oman was at his home with girlfriend and her family. He got into a disagreement with them at some point, told them to leave, went to the bar, they were still there. I think this would be a good way of striking. He blew a gas. He blew a gas, very angry at them in that confrontation. Things would have gone differently. Either they weren't still there, or if he had not there. So I think this disposition appreciates what happened there, as well as really the only issue I think he has is the drinking.
All right, thank you. Mr. Chapman?
Was he disorderly? Yes. Could a jury have found this as being justifiably disorderly?
Yes.
This was his cabin. His girlfriend had her own place. He was fully justified in kicking people out of the house. I don't think they were really in any position to tell him not to smoke in his cabin. Camper. But did he handle it properly? He has no prior record. He's done an assessment. He's doing outpatient treatment. I agree. This is acceptable. The public will be protected.
Mr. Ullman, do you want to say anything today?
No, I believe everything's been said.
Okay, I think this agreement is appropriate. You've taken the steps that you need to address the issues that you have, your alcohol issues, as well as doing a domestic violence course, and you did so without being ordered to do that. So you got the benefits of this offer. Plus you get the benefits for your life. So I think that that's appropriate. I don't think the public is at risk. I've learned a lot, and so that this is a reasonable agreement. So I'll accept it. I will assess $600, $500 for costs and surcharge, plus a $100 domestic abuse surcharge, for a total of $600. We do have $2,000 posted, so the rest will be remitted back in a couple weeks. Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is ordering you DNA to the Burnett County Sheriff's Office. If they need it, they'll take it. If they don't need it, they'll send you on your way. You have the right to request it be through the system, through a written letter to the Department of Justice. Not to the court, but not to the Department of Justice. So what you're going to need to do, you're going to need to take a form here and go to the Sheriff's Department, provide your DNA, and then you should be good to go. Okay? All right,
Okay.
Mr. Schmidt, is there anything else that the court's missing? Mr. Chapman?
Nothing else. Thank you.
All right.
Nothing